Live from Marina Bodie's house. Today we're going to be talking about physician-assisted suicide, commonly confused with euthanasia. The difference about physician-assisted suicide is that physicians provide terminally ill patients with lethal drugs. Patients receiving drugs perform the act in their own life. With euthanasia, the physician providing the drugs, the physician performs the act.
Requirements. The patient must have a terminal disease with less than 6 months to live. Have to be 18 years old, residents of the state that legalizes it. Physician explains the process of their disease and all the other possible options available. Patients request PAS orally. Patients sign a written request with 2 witnesses present. Patient requests PAS orally again 15 days after the request. Another physician examines the patient to confirm his or her mental stability and disease. Physicians and pharmacists are protected by the law and may withdraw from providing drugs at any time.
The medicine commonly given is a pill of 9 grams of secobarbital and capsules of pentobarbital liquid. The pills are recommended to be taken on an empty stomach to increase absorption. 1 hour before lethal dose, something must be taken to prevent nausea and vomiting. After the lethal dose is taken, someone present must contact emergency medical services to begin the life-saving measures. Time from taking the medicine to death ranges from 2 minutes to 5 days.
Okay, the legal states. First state to pass the Death with Dignity Act was Oregon in 1997. Second state to pass the same act was Washington, enacted in March of 2009. The third state was Vermont, who passed a Patient Choice and Control at the End of Life Act, less restrictive than Oregon's act. Montana became legalized in December of 2008 by a Supreme Court ruling on the Baxter versus Montana case. Montana will be the first court ruling. Other states were decided off legislation ruling.
The first case, Vacco versus Quill, Dr. Timothy Quill and several other physicians and 3 critically ill patients challenged the constitutionality of New York's ban of suicides facilitated by doctors. New York law allowed patients the right to refuse life-saving treatment. The physicians argued that permitting physician-assisted suicide would essentially be the same thing. The question, whether New York's ban on physician-assisted suicide violated the 14th Amendment's Equal Protection Clause.
2. This is page 3.
Right. Yeah, you're right. Okay. Cut that out. Case 2.
Yeah.
The court reasoned that the state has a legitimate interest in ensuring the safety of the public and in ensuring that medical ethics are preserved, especially as it applies to preventing euthanasia. The court asserted that people have the right to die, but that their right to die must relate to their decision and ability to end their own lives.
Case 2, Washington versus Glucksberg. Dr. Glucksberg, 4 physicians and 3 terminally ill patients challenged whether Washington's prohibition against causing or aiding a suicide offends the 14th Amendment of the Constitution. Their argument was that assisted suicide was a liberty protected by the Due Process Clause of the 14th Amendment. On January 8th of 1997, the case was argued in front of the U.S. Supreme Court, and the ruling stated that the ban was rational because it furthered various compelling states' interests, primarily the preservation of human life and protecting the mentally ill or disabled from medical malpractice. If court declared physician-assisted suicide a constitutional right, the nation would start down a path to voluntary or perhaps involuntary assisted suicide. So it is not a crime, but a state's choice.
Politics involving assisted suicide. Recent laws in Oregon and the UK have started the trend of legalization. A poll taken this year showed that 50% of Americans want to legalize physician-assisted suicide, while 29% said it should be legal. Majorities of both Democrats and Independents who were surveyed said that assisted suicide should be legal.
Arguments for physician-assisted suicide. It maximizes the enjoyment of life and minimizes the pain. Authority to arrange their own deaths can reduce suffering and is the right to autonomy. If patient's best interest is death, then the physician should act to achieve that end. Arguments against physician-assisted suicide. Human life is an inviolable gift from God. Life at every stage is precious. We are stewards of God, not dictators. Important to know both sides of the argument so you can decide your own opinion. The Catholic principles. The Catholic Church views assisted suicide and euthanasia as a direct killing of a human being, therefore making it an immoral act. The Catholic Catechism, paragraph 2277, states, "Whatever its motives and means, direct euthanasia consists in putting an end to the lives of handicapped, sick, or dying persons. It is morally unacceptable."
The sacredness of the human life and dignity is becoming a preference with the ability to choose the end of life. Pope John Paul spoke about this issue. When the prevailing tendency is to value life only to the extent that it brings pleasure and well-being, suffering seems like an unbearable setback, something from which one must be freed at all costs. Pope John Paul II also says that true compassion calls us to share in their suffering. So those who are terminally ill should receive palliative care and pain relief as long as it does not take away the experience of life and death.
In courts, conversation, and media, the issue of euthanasia and the right to die is a major topic. We should be informed on the different opinions and Catholic teachings so we can respond appropriately to these present problems. The questions we must know how to answer are: is life only valuable when we are healthy? Are we the ones who decide when we die? Is suffering meaningless?
That way.
We'll see.
Wait. This is a 15-minute video?
Right. Oh.
Ah.